Hello and welcome to Book Breaks. We're so thrilled to have you here as we discuss Before the Movement, the hidden history of Black civil rights. And as always, we'd like to thank Citizen Travelers, the nonpartisan civic engagement initiative of the Travelers Companies, for their continued support of Book Breaks. And I'm your host, Gina Oppenheim, and I'm joined by my friend Ryan. Hey, Ryan. And without further ado, we are so thrilled to welcome Professor Dylan C. Penningroth, who is a professor of law and history at the University of California, Berkeley, and a 2012 MacArthur Fellow. Welcome, Professor. We're so happy to have you here today.
Thank you so much for having me.
Now, just to start off, can you give us an overview of this work we're going to be talking about today?
Sure. So the book is called Before the Movement, The Hidden History of Black Civil Rights. And in this book, I really wanted to try to do two main things. One was to ask a question: what would Black history look like if we put Black people at the center of it? That may seem like an odd question to ask, and I can come back to what I mean by that in a moment. But for now, I'll just say that typically when we think about or write about African American history, what we're really writing about is race relations. That is to say, how did Black people resist white oppression, whether that be slavery or Jim Crow or today's assault on voting rights? The story is one that always has white people or white-dominated power structures at the center. My book takes seriously those white-dominated power structures. It takes seriously race relations. But the real heart of the book is Black people's relationships with one another, their families, their communities, their churches, all of the ways that they interacted with one another. The second question that I wanted to ask in this book is, how did civil rights become Black rights? So when you think back about what civil rights meant in, say, 1840, most Americans would have said that civil rights meant essentially the right to property, the right to make contracts, and the right to sue and be sued, the right to go to court. By 1954, you can see it in Life magazine, you can see it in presidential addresses, civil rights had essentially become equivalent to Black rights, or as they said at the time, Negro rights. And I wanted to know why. There's a story that really springs to mind that gets at that transition, that transformation, the idea of civil rights. And it's a story that comes from 1973, around Christmas time, when the great journalist and historian Richard Kluger interviewed Thurgood Marshall for this book, Simple Justice, that he was writing. Many of you in the audience may have read this book. And in the book, Kluger asks Marshall essentially, why did you use the doll tests? Some of you may know that the doll tests are these psychology experiments that the NAACP Legal Defense Fund legal team used to prove that segregation harmed Black children. It was one of the keystones of the argument. And that footnote, that citation, that reliance on the psychology cases, the experiments by Kenneth and Mamie Clark, immediately became controversial. And to this day is kind of a touchstone for controversy. So Kluger wanted to know, why did you use these doll tests if you knew they were going to be so controversial? And Marshall's answer, I thought, was really telling. He said, you know, this case, this segregation case, the school segregation case, I wanted to try it just like any other case with damages. If your client ran over my client's foot with his car, then I would sue your client for damages. And these school segregations, they harm Black children in the same way that a car harms someone who runs over someone else's foot. That really made an impression on me. And I came to realize that what Marshall is saying is that Black people knew about civil rights. They knew all about going to court to sue over things like property and contract and torts. They spoke the language of damages, and I wanted to get the heart of why it was, how it was that they came to understand it so well.
Wow, amazing. Now, you opened the chapter with the story of Thomas Holcomb. Can you tell us about him and how he inspired you?
Of course. So Thomas Holcomb was my great uncle. He grew up in Virginia, Cumberland County, Virginia. That's a place that I visited from time to time when I was a small child. We used to go home. I should say, we used to go visit Cumberland. I grew up in New Jersey. And Thomas Holcomb left Virginia in 1927, and he spent his whole adult life in New Jersey. And when he was an old man, the year before he died, my uncle, Craig Baskerville, interviewed him and recorded the interview. And Uncle Craig asked him questions about life on the farm. Why did you leave? Essentially, the answer was they were too poor, they weren't making it. But first he asked him about his own father, a man named Jackson Holcomb. And the first thing that Thomas Holcomb says is, my father was a slavery man, and my mother was in slavery too. And then the next thing he does is he begins to tell a story about Jackson Holcomb owning a boat and a bunch of Confederate soldiers running through the woods after the Battle of Richmond. They come to the Appomattox River and they ask for a ride across the river. Now, remember, they're desperate, they're hungry, they've just been through battle and they've lost. They come to the side of the river and they ask for a ride across. When they get to the other side, they paid him. They took out money and they paid Jackson Holcomb for the ferry ride. And I thought that was very odd. Why would they do that? They didn't need to do it. They weren't legally compelled to do it, and they certainly had all the guns. And I came to realize as I did the research that the reason they did it is because they were used to dealing with enslaved people. They were used to making bargains. They were used to seeing enslaved people own things like boats and horses and chickens and cattle. And they were participating in the same world of law that white people did. That's kind of the story that launched me down the path that became this book. But as you can see, it was a story that began with my own family. And if you read the book, you'll see that family plays a role at different points of the book, my own family as well as other people's families.
Yeah, so fascinating. And in the first chapter, you also write, to understand slavery, you must look at the legal lives of slaves. Can you tell us what you mean by that?
Absolutely. So that kind of seems like an oxymoron, right? Like, how could slaves have legal lives other than to be subjected to law, to be violated by law? Slaves are typically seen as being outside the law, something that law acts on. That's certainly true, but there's also an important way in which enslaved people were unequal co-participants in the same world of law that ordinary white people were. So I should explain what I mean by that. If you think about buying a house, one of the things that happens when you buy a house is you sit, with an agent from Chicago Title. So you've got your real estate agent, you go to a lawyer, and then there's someone from the title company, and you sign basically 150 pieces of paper, and you barely know what you're signing. You turn the pages over and over again. But a lot of what you're signing has to do with putting the transaction on public record. You are putting the world on notice that this piece of property is being transferred legally from person A to person B. That is the foundation of our property system. And that more broad concept of notice is the foundation of many, many different areas of law. Enslaved people participated in that same system. They didn't have rights. They couldn't go to court to enforce. My great uncle Jackson Holcomb couldn't have sued to recover the boat if the soldiers took it from him or if they refused to pay him. But the reason he was able to own the boat is because he had the boat and he purposely put it in front of people. He made it a matter of public notice. He couldn't go to the courthouse and put it on record that way. But by putting it in places and using it in public, and so that white people and Black people could see him with it every day, he tried to put it on record, sort of inscribe it in the public's mind in much the same way, using the same logic that we do today when we sit with Chicago Title and we sign all those papers.
Wow, yeah. Uh, so, what was notable about Oregon's petition for statehood in 1858? I love how many different stories you weave into this book, and that was a fascinating one too.
Well, the funny thing that Oregon did in 1858 when it petitioned for statehood is it included in it a prohibition on free African Americans or enslaved African Americans being resident in the state. In other words, they were trying to abridge Article 4 of the Constitution, which says that, you know, citizens have the right to move between states and reside in the several states. So Oregon was clearly defying the Constitution in that way, but as a political matter, the Republican Party, Abraham Lincoln in particular, had to decide whether they were going to do anything about it. They did. The reason they did, and Eric Foner has described this beautifully in his 1970 book, Free Labor, Free Soil, Free Labor, Free Men, is they decided that proscribing free people from residing in a state, from having certain basic rights that are guaranteed under state law and under federal law, such as the right to property, the right to contract, the right to sue and be sued, was a bridge too far, that all free men were entitled to those basic rights. That becomes a winning formula. Abe Lincoln goes on the campaign trail and he says, look, you don't have to believe that Black people should have the right to vote, or that they should have the right to go to school with white people, or that they should have the right to marry white people. But, and I'll quote here, he says that the right to eat the bread which his own sweat has earned, which he's earned by the sweat of his own brow, that is the right of a Black man, of any white man, of any free man. That's a winning formula. It carries Abraham Lincoln to the White House. And it really kind of, that challenge is crystallized in Oregon's petition for statehood. That in turn creates some questions, which we can get into if you want, about what rights free people will have after slavery, whether those will only the ones that Abraham Lincoln described as the most basic rights, whether that's going to be the maximum that free African Americans will have after the Civil War and after slavery is over, or whether there's something more that goes with being free.
Yeah, you use a lot of amazing phrases in the book, and I was wondering if you can define for us the technologies of public action, because I hadn't heard that used before.
Sure. So that's a phrase that I'm borrowing from Hendrik Hartog, a really eminent historian at Princeton University, now emeritus. And what he was talking about there was corporation law. And it turns out that corporations play a surprisingly large role in African American history. And they do that in large part because they enable people to collect together and channel their private individual energies in, you might say, a public direction. So, you can think of all sorts of corporations that are private but have a public impact. One is, Yale University, where I went to school. Some white people at the time talked about the United States as an association of white people. So this idea of the corporation, the association in legal terms, as something that has both private and public dimensions is really prevalent then as it is now. Anyone who follows the debate over ESG will know, environmental and social governance, you'll know that we're still debating what kinds of public duties a supposedly private entity like a corporation, like Exxon, owes. It's no different in the 19th century. And it has a particularly keen bite for African Americans who are creating corporations like churches, like colored conventions to argue against slavery and argue for equal rights for African Americans, but who nevertheless also want to control their membership and they want to be able to control the rights of members. So there's this internal and external dimension to Black corporations. And Black corporations also have this extra dimension where they have to ask themselves whether they owe a duty not just to the public and not just to the shareholders or the members, but whether they owe a duty to something called the race, something that's not quite the entire public at large, but not as narrow as any individual member or shareholder. And African Americans struggle over that again and again and again. And they argue internally over it. They don't always agree. And out of those arguments, some of them go to court. They begin, I think, to trace for us the contours of an intellectual history of Black identity and of Black legal thought.
Yeah. So speaking of legal thought, you mention a lot of cases in the book. So we have Dred Scott, Plessy versus Ferguson, but a lesser known case that I wasn't very familiar with was the Slaughterhouse decision. Can you tell us about that?
Sure. So the slaughterhouse cases of 1873, that's a case that involves a bunch of ex-Confederate butchers who are angry because the city of New Orleans has decided, in the name of public health, to award a monopoly on butchering in the city of New Orleans to one slaughterhouse company. The white butchers get together and they sue, claiming that their fundamental rights have been abridged. Specifically, they say that their right to earn a living has been abrogated by this state action. The court decides, among other things, that only a state action can abridge these rights, and that absent that, the butchers have no case. But some of the things that come out of this case that I think are a bit less well known are that the butchers are making, among other things, an argument that hinges on white men's fundamental rights. And the court specifically singles out race. That is to say, that the 13th and 14th Amendments are amendments that were passed specifically to protect the rights of ex-slaves. But the Confederate butchers, they're making an argument that they want to sweep much wider. They want to say that fundamental rights of all free men are being abridged. So in an ironic way, the Supreme Court, by singling out race, by specifically saying that that the facts of this case are all about enslaved people, that this is a case about the 13th Amendment, about the badges and incidents of slavery, they are narrowing the facts of the case. And that is sort of the beginning of a story that I carry through the book that's about opportunistic uses of race. So over and over again, you see the Supreme Court, you see other courts doing this. Sometimes they bring out race, right? They specifically make sure to mention that the plaintiff was Black or that it matters that the plaintiff was a Black person. Other times they look at a Black plaintiff and then they hide the facts of that case. They specifically pretend that race doesn't exist in the case or that race doesn't matter. They sometimes strip words like colored and Black out of the case. It's not part of a grand conspiracy, I think, to rob Black people of their place in the case books, but that's exactly what happens. What these courts are doing is they're pursuing their own narrow legal ends. They want this case to sweep widely and they want that case to sweep narrowly. But the end result is the same, which is that today, when you go and open up your contracts casebook as a first-year law student, and all law students have to take contracts, you will see only one case in contracts that even hints that Black people were involved. And that's a case in a relatively, not quite obscure, but not a really prominent area of contract law, the law of unconscionability. But in fact, if you're a historian and you kind of know what to look for, you can find 3 or 4 other cases involving Black people as well as a bunch of theoretical interventions by the casebook professors that rely on ideas about slavery. None of those is marked. And so law students, they get trained and they're trained to think, John Roberts obviously is trained to think that the only place where race matters is in constitutional law, certain areas of constitutional law, and certain areas of criminal law. That is to say, race is just an add-on. It's not really important to the fundamentals of what lawyers have to learn and what lawyers do. And that's just false. Race is almost everywhere in our law.
Yeah. And now, during Reconstruction, how were civil rights formed within civil law and not against it? So I thought that was a fascinating thing you write about.
Yeah, that I like the way you phrase that question. So I think that often the way that I was learning about Black civil rights during Reconstruction was that Black people were asserting their rights in defiance of white power brokers, specifically at the county level, who wanted to keep rights away from them. And as I researched this book, I realized that that story is true, but only for certain kinds of rights. So if you wanted to assert a right to vote, the local courthouse was not going to allow you to do that. Same thing again goes for asserting a right to marry someone of a different race. But the courthouses were surprisingly open to people who wanted to assert a right to property or a right to make contracts or a right to sue and be sued. So I'll just give you a couple of examples. In 1872, something like 7% of the cases that I looked at, and I went to a couple of dozen, about 25 county courthouses scattered around 4 states and the District of Columbia. And I went and I collected a large sample of about 14,000 cases, about 28,000 litigants from 1872 to 1962. And I tried to find out whether Black people were going to court. I can talk a little bit later about my method and how I did that, me and my research assistants. But the main thing I want to emphasize here is that in 1872, Black plaintiffs were about 7% of the total plaintiffs in the states that I was looking at. And that percentage rose to over 20% by 1922. That is to say, Black people were routinely going into local courts to sue people, usually suing other Black people, sometimes suing white people. And, there are some interesting reasons why the courts were so open to them. But that became sort of the leading edge of my inquiry. Once I realized that Black people were going to local courts, I wanted to know what they were doing there. And it turns out that a lot of what they were doing there, it had to do with their own families, their own churches, their own sense of who they were as individuals and as collectives. That story is right there in the local court records, which, for the most part, people don't consult them. They're largely unexamined and they're just waiting for people to come look.
Yeah, well, your research process is fascinating. So I was wondering if you could share with us some of your favorite discoveries. You've shared a few, but some of your big aha moments in your research process.
Sure, sure. So, one was, as I just mentioned a bit ago, realizing how common it was for African Americans to go to their local courts. Um, Another, I think, was finding cases that brought out the ways that Black people thought about fundamental facts of life. So, just to take one example, after slavery, you have millions of African Americans, about 4 million people who have been in slavery, and they now have to think about old age care. This is obviously something that we continue to think about, but sick care, old age care, white ex-slave owners are now signaling that they are no longer going to support African Americans in old age and in sickness. And so now African Americans are going to have to do that themselves. And they do. And the ways that they do it have to do with law. They make bargains with one another. for old age care. So just to take an example, there's one woman who I looked at named Eliza Brown, who was enslaved in Maryland. And then she moved to Washington, D.C. And sometime around 1880, she goes and finds a lawyer, so a man she used to work for. And she asks this lawyer to draw up papers for her to leave her property. By then, she's got a house she's earned from washing clothes for 20 years. She wants to leave her property, not to her own blood family, but to her best friend's daughter, a woman named Henrietta Jefferson. And so the lawyer draws up the papers. And when Eliza Brown dies a few years later, the lawyer puts that deed on record, and Henrietta Jefferson becomes the owner of this house in Washington, D.C. It's a valuable place. The reason that Eliza Brown does this is because Henrietta Jefferson feels like family to her. She's taken care of her for years. She's done her washing. She's fed her. Clearly, toward the end of her life, she's nursed her, through her last illness. And this is why she gives her property to her. But Eliza Brown says something else. She says that her own relatives, she says, I did have relatives once, but they never did anything for me. They didn't do for me. But Henrietta Jefferson did for me, and I'm going to leave my property to her. Now, of course, when the blood relatives get wind of this, they come north, they come south, and they sue. They come down from Baltimore, and they lose. And I think the takeaway from that case for me is, number one, that Black people have their own ideas about what a family is and what family members owe one another. And second, that in some circumstances, white judges are perfectly willing to honor Black people's ideas of family, to recognize them, to take an interest in Black people's ideas of family. Why? Because white people's own rights are implicated.
Wow, yes. I could ask you so many more questions, and I'm just going to ask one more and then pass you over to Ryan. I was just wondering what you hope readers take away upon finishing this book.
I guess there are a few things that I hope, but one is just I hope that readers come away with an appreciation for the diversity of Black experience. I said at the beginning that often there's a way in which we think of Black history as being equivalent to the history of race relations. And I think that race relations plays a really important role in African American history. And I also think that we can complement it by expanding our vision to think about Black people's relations with one another. The second thing that I hope readers will take away is that the story of Black people's exercise of rights is a story that takes place alongside horrific acts of racial violence, anti-Black violence, right? So, for example, the peak of Black land ownership is around 1910. That's also the peak of lynching in the United States from 1890 to about 1910. And what I think we can take away from that is that Black people's exercise of rights coexists with anti-Black violence, that the two things are not mutually exclusive, that just because Black people had certain rights and were able to exercise certain rights does not mean that they were fine, or that police violence like George Floyd doesn't happen or doesn't mean anything. But the second thing that I think it does is it should cause us to wonder, why is it that after so many years of anti-Black violence, why is it that in the 1950s and 60s, Black people were willing to put their faith in the rule of law? I think that question is one that takes on an especial significance in our own day when we have the leaders of one of our two major political parties who is openly undermining the very idea of the rule of law.
Well, thank you so much. And without further ado, I'm going to pass you over to Ryan, who's going to start with our Student Scholar of the Week.
Yeah, thank you so much, Gina, for that wonderful back and forth. It was awesome to listen to. And as our loyal listeners know, but for some newer folks, we always begin this part of the program with our History Scholar question of the week. So this is a weekly competition in which students have a chance to ask our guests a question for a chance for themselves and their teacher to win a $50 gift card to the Gilder Lehrman Institute of American History gift shop. The questions are normally quite good, and I think this week is no exception. So Sandra, who is a student in Miss Madden's class in Stuyvesant High School in Manhattan, not too far from our office, asks, how did local and state legal systems respond to increasingly legal engagement of African Americans in the 19th century? Were there notable differences across regions in the U.S.? And Sandra says, thank you. She loves the book.
Thank you so much for that question. And Stuyvesant High School, my best buddy from college went there. So your question rings an extra bell for me. So how did local and state legal systems respond to African Americans' claims of rights? It's a great question. There was variation across the regions. There were a lot higher percentages of Black plaintiffs in local courts in the South than in the North. But I don't think that that's because the courts in the South were more open. I think it's because there were simply higher percentages of African Americans in those states. And I know this in part because when you break it down county by county, you can see a rough correlation. So I guess that's sort of the first answer to your question. The second one is that state courts heard claims from African Americans, and those cases, in many instances, became part of the common law of those states, right? So there are cases on property, cases on contract, cases on family law that they don't necessarily say when you look them up in Westlaw or the state reports, they don't necessarily say that Black people were involved. But when you go and look at the facts of the case, you realize that these were cases involving former slaves. A great example is cases involving religious associations. So the private law of religion, basically, what rights do religious corporations have with respect to their members? One of the leading cases on that is a case called Alexander versus Bolden from 1872. And together with a case called Watson versus Jones, it helped shape the federal law as well as the state law of religious associations' control of property, their ability to appoint ministers, the ways that they treat members. And this case gets cited all the way down to the late 1960s. William Rehnquist actually cites it in a 1969 case. So these state and local courts are quite open to claims by African Americans.
Fascinating. Thank you so much for that great answer. And thank you again to Sandra for the wonderful question. Sam in our audience is wondering, did you look into in your research, did you look into Black feminist struggles of the late 19th and early 20th century at all, especially as it's related to the women's suffrage movement and the many layers of that movement with race?
Sure. Here, I just want to give a shout out at the beginning to a book that I relied on very much throughout the writing, and that's Martha Jones, All Bound Up Together. She, I think, is probably, the person I would point readers to with respect to Black women's struggles for equality in the late 19th, early 20th centuries. And part of what I was doing in this book is I was less concerned with how African American women were engaging with white women over questions like voting, suffrage. What I was mainly interested in was African American women's efforts to achieve suffrage within their own communities, within their own churches, within their own activist organizations. So, I would say that anyone who's interested in Black feminist struggles, anyone who's interested in African American history more generally, it can be really rewarding. And I've been telling myself that I want to do more of this, to look at corporation law, to look at corporate law. We often think of, corporations as being, kind of, this is the man, this is the tool that keeps us down, and it is, right? It certainly is all those things. But again and again, you find African Americans creating corporations for themselves. So, for example, my great uncle Thomas Holcomb, their family was involved in creating a church called Midway Baptist Church. They do it in 1874, and they specifically create it as Midway Colored Baptist Church. And they do this in part because they know that the law of property and the law of church property, this private law of religion that I mentioned a bit ago, will protect their right to the church against white people who want to take it away from them, so long as they insert something into the deed that identifies it as a Black association, a Black corporation. That relationship with the outside world isn't the end of the story, though, because once they've created this Black church, there are still questions about what are the rights of the members of that church. And again, from Dexter Avenue Baptist Church, the one that King headed, to Ebenezer, to Malcolm X's Nation of Islam, you find again and again that leaders of Black-run religious corporations like churches and mosques, they centralize authority in the leader, and they are constantly trying to take away rights from the members. And the one thing that I think you have to know about Black religious organizations is that something like 2/3 of the members at most points in time are women. So you have corporation law that empowers a Black collectivity to protect itself against white domination, but whose leaders are using those same rules of property and contract and corporation law to subordinate women within these Black collectivities.
Wow, fascinating. Thank you so much for that great question and great answer. Another interesting question from our chat, who's very engaged today, is because Black struggles for what we today would call civil rights goes back as far as one want to go, even before the Revolution, and certainly just after the Revolutionary era. How did you come to start your book in the 19th century? Why that period specifically? Did you consider a different time frame or methodology?
No, that's a great question. I think I probably started it in the 1840s because it was already going to be 100 years worth of history, and I couldn't imagine going back any further. Perhaps someone will write, a different book that can look at these things. I should say, though, that my book, I see my book as building on the work of previous scholars, many of whom did work or have worked on the period that you're talking about, the 18th century, the period before the 1840s. And here I'm thinking of people like Laura Edwards, of people like Martha Jones, but I'm also thinking of people like Luther Porter Jackson, Black historians who went to local county courthouses the same as I did, but they did it in the 1940s and the 1930s, a time when people like us weren't exactly welcome wandering around the courthouses of Virginia and Mississippi. So they're doing this research in an unfathomably more difficult time for a Black historian to do research. And they come out of it with this incredibly keen appreciation for the ways in which, just as you said, free African Americans before the Civil War, even before the Revolution, are actively using, they're exercising rights of property and contract and the right to sue and be sued. Now, the reason that Luther Porter Jackson and men like him are researching there is because they are building an argument for civil rights. That is to say, the rights of Black people in the 1940s to have the equal rights, these political, the right to vote, social rights like the right to go to school with white children. Luther Porter Jackson is saying that because free African Americans, because our ancestors in 1700 were responsibly exercising these rights, because of this record of achievement in the world of property, the world of religion, we deserve, their descendants, we deserve to have equal rights in all spheres of American life here today.
Fascinating. Thank you so much for that. As we mentioned right before we signed on, we have so many teachers on the call today, and more, thousands in our network, and much more will watch the recording in the future. And so I'm sure this will not be our last question today in the remaining time that we have about kind of educational practices. But John asks a really important question, I think. John says, in our current educational culture, with many educators being the graduates of educational departments and not history departments, that is, they achieve teaching certificates, but they're not history majors, and who teach primarily from generalized textbooks, how can they teach effectively the difference between lowercase Black rights and uppercase Black civil rights, like the one you discuss in your book?
That's an interesting question. I think maybe the way that one might lead students through the exercise is to begin exactly where you did, lowercase versus uppercase Black rights, and maybe just ask students what they think that distinction might mean, and then sort of pull them back and show them what civil rights meant at different points in time. There are different primary sources that one could use to show the evolution of this distinction that I've been describing between lowercase and uppercase Black rights. I think maybe the way to draw students in at bottom might be to sort of hook this question onto some live current day issue that I think everyone is probably aware of. So for example, colorblindness, right? Like John Roberts, keeps telling us that the way to stop discriminating by race is to stop discriminating by race. And of course, it's tautological. It doesn't really make sense. And I don't think that he pretends that it makes sense. He's just simply declaring it to be so. But I think that if you can start students off by getting them to think about what that tautological statement is trying to do and what assumptions it's relying on, you can start to have a conversation about what it means to discriminate by race, what work race is doing in judicial rhetoric, and then you can pull cases. You can just look at the footnotes of different books and pull up cases. You can pull the texts of these cases from legal databases, and look to see how they're treating race. So if you have a case that involves Black people, but it doesn't say anything about race, you can ask your students, well, why is that? Why aren't they talking about race? And vice versa, in a case like the slaughterhouse cases, you can pull it up and you can say, okay, here's a case that involves a bunch of white butchers. It seems like a perfect opportunity to not talk about race, right? Like whiteness is supposed to be the default category. Why then does the Supreme Court deliberately choose to put race not just into the decision, but make it the centerpiece, the hinge point of that decision? So I think like those are some ways that one can begin to get students to think about what kind of ideological, what kind of legal, what kind of cultural and political work race is doing in our society.
Fascinating. Thank you so much, John, for that question and for that answer. And Professor, if you don't mind, I could briefly follow up and just ask you, we've heard, and there's links in the chat to purchase this great book, and we hope that many in our audience do, and I'm sure many will. How could teachers in the classroom utilize your great work in their classroom? Are there specific chapters? Does your work especially go well with specific periods? Maybe as an addition to the Reconstruction period, or the a different way of looking, of course, the civil rights movement. How can your work, any insights into how teachers can use your work in the classroom if they choose to?
I appreciate that question. So a minute ago, I said that I didn't want to extend too far back because it would overwhelm me. I'd drown. But now I'll say that the book really does extend over a very long period of time. I think it's fairly unusual for a work of history, especially African American history, to go from the 1830s through the 1970s. And what I hope that allows teachers to do is to pick chapters that will work for them. So there are themes that extend throughout the book. And, depending on where you are in your syllabus, you can choose a chapter that will work for you. So for example, if you wanted to think about the beginnings of the legal fight against segregation, leading up to Brown versus Board of Education, and then leading forward to today's struggles over affirmative action in education, in college admissions. If you want to talk about that, you can look to the chapter, I think it's chapter 11, where Thurgood Marshall is talking about school segregation as something that damages Black children the same way that, a car accident hurts a Black child. And that can sort of be a way to situate students in a world where Black lawyers are thinking not just about discrimination on the basis of race, but they're thinking about this whole world of Black legal experience, Black legal savvy, Black legal knowledge, Black legal thought, where ordinary African Americans are dealing with law all the time. And Black lawyers like Thurgood Marshall, they're keenly aware of that, and they appeal to it. So there are different ways, different parts of the book that I think can be used appropriately for many different parts of of a syllabus.
Fascinating. Thank you so much. Changing beats a little bit, and as you may or may not know, Professor, we're also known as the Institute of Lincoln. We do so much Lincoln related stuff and work here. And to that point, we have a question about Lincoln, and if you wouldn't mind just talking a little bit about how, in your view, his views on race and the rights of Black Americans seem to kind of shift from enslaved to post emancipation. Anything any insights that you could give to that point?
Sure. So Lincoln, of course, is murdered just a few days after the Civil War ends, and so much of what we know about Lincoln's views, I think, reflects an evolution that he is experiencing during the Civil War rather than after the Civil War. He certainly does undergo an evolution. He clearly comes out of a certain milieu in American history, that enables him to so willingly and effectively glom onto that three-part ideal of rights, where African Americans are entitled to the fundamental rights of all free men, but not political rights, not social rights. He's sort of a willing participant in that. But I think the really fascinating story is what you might call the Lincoln Republican Party does with Lincoln's vision after the Civil War, which is that it becomes the foundation of a profoundly conservative, in some ways anti-worker and even anti-democratic movement on the Supreme Court and on many state Supreme Courts. We think of the Republican Party as the party of freedom, and indeed it was, but it was a very limited kind of freedom, and it was specifically limited by this vision of rights that Lincoln so effectively wrote into our national consciousness. So you have a Supreme Court that, by the 1880s and 1890s is proscribing the right to strike for better wages. They are striking down state regulations that are meant to protect workers, protect their lungs from being damaged, to protect their hands and arms from being harmed in the workplace. The Supreme Court just strikes those down because, the court says, these infringe on liberty of contract. Again, these fundamental rights of all free men. So here again, you have this debate that starts in a struggle over slavery, right? What are the fundamental rights of all free men? But by 1900, it's become a sword that gets used to strike against what white working people believe to be their rights. And so there's this really interesting evolution that happens not just in Lincoln's thought, but in the Republican Party more generally.
Fascinating. Thank you so much for that great question and answer. And just keeping an eye on time, I think we have time for maybe one or two more questions. And I know Gina already asked about kind of aha moments in the archives, but I think our audience would really like to know just if you could dive a little bit deeper into process, what archives you kind of relied upon, just your methodology. How was this process different from other works that you've put forth in the past? Really, any way you would like to talk about that, but I think that our audience would really appreciate that.
Sure. This book took a long time. It took 20 years, in fact. And part of the reason it took such a long time is because it's rooted in large part in these local county courthouse records. They're not digitized. They're not Xerox. They're not available anywhere except at the local county courthouse. And so that's where I went. I would rent a car, I'd get on a plane, I'd get on Southwest and go to Mississippi, Holly Springs, something like that. And I would pull up, I'd usually call ahead, and I would ask the circuit clerk or the deputy clerk whether it was okay for me to go in the back and look at the old stuff. And 9 times out of 10, they said, sure, fine, because really they don't care. As long as you stay out of their way, they can get on with their real business, which is processing traffic tickets and recording property deeds. So I would go in the back and I would pull down these big, heavy ledger books. They're about this big. They weigh something like 10 pounds each. They're leather bound or cloth bound. And on those ledger books are written the plaintiff and defendant for one case after another, case number 1, number 2, number 3, on to case 30,000. These docket books are all lined up on the shelf, and I would pull them down in regular intervals, 10 years apart, because I wanted to get as random as I could, sample so that I could get a true picture of how often Black people went into these courts. And I would copy down the names. Or I'd take photographs, and then my research assistants would copy down the names. And then we would look them up in Ancestry.com, because I found very quickly that on these ledger books, with millions and millions of cases, most of them taken from the period when Jim Crow was at its peak, not one of them said what race the litigants were. So you can just leaf through page after page, and you will not find a marking that says colored or Negro or Black. You just won't find it. So this is kind of a problem. I wanted to write a book about African-American history, and I couldn't tell who's Black. So Ancestry.com, not the cheek swab portion of it, but the census, digitized census portion of it, that's what enabled us to do it. We looked up something like 28,000 litigants, 14,000 cases, and we found that something like 1,500 of them involved African Americans as litigants. That's a significant percentage. And those are, in large part, the cases that we looked at, because behind each one of those case names is a folder. And in that folder are stories. And those stories were the basis for this book.
Wow. Fascinating. And I think that's a perfect opportunity to throw it back to Gina for some final thoughts. I'm so sorry if we didn't get to all the questions. But again, as I've said in the past, and it's certainly true this week, a great remedy for that is getting your hands on this wonderful book. There's links in the chat, so we encourage everyone to do so. All your answers can be found there. Gina, back to you for some final thoughts.
Yes, absolutely. And if you get the book today through bookshop.org, the affiliate commission we receive supports our programming for history teachers and students. And we hope you'll join us next week as we welcome our friend Richard Brookhiser and his book, Glorious Lessons, John Trumbull, Painter of the American Revolution. And as always, you can go to gaildurlerman.org for documents, essays, digital exhibitions, the Hamilton Education Program, and so much more. Professor, thank you so much for joining us today. This was a fantastic session.
Thank you for having me.
Right. Have a good day, everyone.